Today, what we're going to be talking about is how to deal with and create home trusts in eState. So I'm going to share my screen, and as I always welcome people to do, you can open up eState on your own, in your own computer, and follow along. Try it out as I'm doing it, seeing what I'm doing. That's the best way to learn. So here we are again with Homer and Marge, and I'm going to demonstrate how Homer says to us, well, we want to create a trust for the house to let Marge live in it because it's a second marriage, for example, and I want to make sure that ultimately it goes to my kids, as an example. So how would I do that? Well, we'd obviously, if we're talking about dealing with what should happen to Marge or to Homer when Marge is still alive, we'd go to the surviving spouse scenario. So we're talking about an initial gift. We're talking about dealing with a specific asset. Anytime you're dealing with a specific asset, we're going to deal with that in the initial gift section. And to create a gift of a specific asset, you just drag the asset from the left into the box initial gifts, and that will start the construction of the gift. So the first thing we need to do is pick who is going to be the beneficiary of this trust for the home. And we're picking Marge as the beneficiary. And now we're creating this gift. So we're going to create a trust gift for the home. We're going to click on trust. Then we are going to go through the checklist. So the great thing about eState is every kind of gift has its own checklist that's unique to that, what we need to answer for that kind of gift. So this is a trust for a residence. So we're going to ask our clients, do we want that to apply only to the existing home or apply it to a substitute property that might be purchased during lifetime? So we're going to click on that and say, yes, we do. We want to apply to any home that we're using as a home at the date of our death. The trustee for the home, typically we're going to have that as the same as the executors. And now one of the key elements to making a trust is how long is it going to last? And so that's the termination of use. So we're going to now add certain triggers for the trust for the home to end. So let's go add. The first one that we're going to probably do is the death. So we're going to probably have it terminate on Marge's death. So let me just go back for a second and demonstrate how I did that. So clicking termination of use, add. So we're creating an event that's going to terminate the use. The first one is the death. So we can actually pick the death of anyone terminating the trust, but we're going to pick, most likely, we're going to pick Marge as her death terminating the trust. And click OK. Now, there might be other events that are going to terminate the trust because the client might say, well, hold on, I want my spouse to be able to live there until they cohabit, for example, or until they remarry, okay? Or until they don't want to live there anymore. In other words, their agreement. So they can agree, okay, I don't want to live here anymore. Sure, that will terminate the trust as well. Maybe I also want to give the trustee discretion to terminate the trust anytime they say they want to. Now, obviously, that's going to be a balance and getting the instructions from the client as to, how much protection do you want for your spouse to be able to live there? Because if trustee can terminate at any time, well, obviously, that's not a lot of protection. So that might be something that you want to pick. And typically, we have earliest or latest of these events, right? The first to occur. Let's skip conditions because probably we don't have a condition on this right now. And now we're going to go down the checklist to say, okay, now who's going to pay the expenses on the property? So eState allows you to sort of do percentages, breaking down any particular expense and having it shared between the beneficiary of the estate. Typically, more typically, you'd have either the beneficiary paying all of the expenses, and if so, you can just click on the box below that, and that will automatically select 100% of the expenses to be paid by the beneficiary, or 100% of the expenses paid by the estate. You could do either of those. Those are just shortcuts. Or you could say, listen, I want the spouse to pay all the utilities and the ordinary repairs, but I want the other expenses paid by the estate. Okay. Now, then the question becomes, okay, how is this going to get funded? Okay, so for the portion that the estate is paying, we can either fund it out of the residue, or we could set up a separate fund for that amount. The downside, let me just talk about paying it out of the residue. You'll see that if I give away the residue completely to someone else, and I say the residue is to pay the expenses, eState's going to warn me. It's going to say, hold on a second. You've got the expenses being paid out of the residue, but there is no residue because it's immediately distributable to someone else. So that's not going to work from a planning point of view. eState will warn you if you do that, okay? The alternative is to say, no, I'm going to set up a separate fund. I'm going to carve out some money to pay the expenses. So then we would click on separate fund as the source for the estate payment. Now, how do we pick the amount? Oftentimes, we leave it to the discretion of the trustee to figure out how much money do we need to set aside, okay? Other times, we might say it's a specific amount, a fixed amount, and we're going to put in the amount. I want you to set aside $150,000. Now, of course, if you run out of money, there's a problem there. So that's why it's difficult to pick. Sometimes we just want to leave it on the residue, okay? From the residue. Let me just remove that. We'll put it back to the residue paying the expenses, okay? And then we have some more options. We say, okay, what about the ability of the trustee to buy a replacement property, sell this property, buy a replacement property, and allow the beneficiary of the trust to stay in that new property? Well, then we would click allow purchase of replacement property. And then it asks you, do you need the consent of the beneficiary to do that? In other words, can the trustee just say, you know what, you're moving? Or do they need the consent of the beneficiary? If we click that, then they're going to need the consent of the beneficiary. If we don't, they're not. Then it asks you things like, now if you buy a new property, if you sell the original property and then buy a new property for less, what happens to the excess proceeds? They have to go somewhere. So either the simplest option is for them to fall into the residue. That may or may not be the right decision. Or you can distribute the excess proceeds to some other person or a group of people, or divide them, or do whatever you would do with any amount of money. And that would be a specific distribution. And then you can add, split things up. You can divide it. So the excess proceeds are 50% going to this person, to Daniel, 50%. And, it can go then, the other 50% is going to Bart, so you can do that kind of thing if you wanted to do a specific distribution of the excess proceeds. Okay. For now, we'll just keep it going to the residue, which is pretty typical. And then
Jordy, can I just make one?
Yeah.
Quick point? The versatility that we're going through is amazing that the tools allow for it, but just a reminder to everyone that this is a really good process to go through with your client.
Right.
Many clients don't understand the kind of variations that are available, and they typically just rely on the lawyer to tell them what to do. And to be able to go through these tools, A, gives you the opportunity to draft it easily with eState, but B, the actual exercise of doing this is a powerful lawyer to client moment that many of us don't use. And it really does help enhance the whole relationship between you and the client. And I went through this morning with a client, and they were just amazed at all of the options and they hadn't thought of. And when you put the options to them, they go, oh, I want to think about that, but they won't even know to think about it if you don't go through this kind of granular exercise. So it's just an observation.
For sure. I mean, I never thought of that many times, as I'm sure all of us do hear that from our clients. That's the value that we can add. So that's important. And we get to the last one, which is, Ian, which is the idea of option to purchase. I mean, maybe we want to allow the spouse to be able to purchase the home from the estate because they want to trust them, just pay the cash into the estate and get the home. So we can build that in. There is this option for resolution you'll see up here. That's if you have more than one beneficiary who might have the option to buy. In this case, there's only the spouse, so they wouldn't really change that resolution. But then there's the question of price. At what price can they buy? At fair market value or a fixed amount? Sometimes clients want a fixed amount. Most often, though, it's let's figure out what the price is when you want to exercise the option and do that. Sometimes, if you have only a percentage interest in the home, let's say Homer only owned 25%, but wanted to give Marge the ability to buy out his 25% so she would own it all, for example. That's a partial interest. If you asked somebody what the fair market value of a partial interest is, they'd say, well, it's actually discounted because you can't do anything with a partial interest. It's actually less than what the percentage value would be because it's only a minority interest. Well, eState gives you the option as to whether you want to discount it for a partial interest or you just want it to be the fair market value multiplied by the percentage interest that you want. So that's what that's talking about there. It can get complicated, but if you just said, look, listen, what's the fair market value of my 5% of the home? Well, if you got a valuator, they would say it's probably less than 5% times the full value because it's only a minority interest. So that's what that's talking about. Then the question is, okay, how are we going to value it? Are we going to use appraisals? You're going to use a certified real estate valuator. You're going to use some other method. And who's going to pick that? Who's going to make the decision about how we're going to appraise it? How many valuations do you want the estate to get, the trustee to get? Is it 1, 2, 3, whatever? If we pick more than one, then there's a question of, do you want to average it, et cetera. So that's just an issue to deal with. And then who should pay for that evaluation, that first one? Should it be the beneficiary? Should it be the residue? Should it be the expense fund or some other option? And then what about discounting for notional commission? So oftentimes the advantage of somebody buying it from the estate as having an option to purchase who's a beneficiary is that there's a discount that you don't have to pay a real estate agent to list it, et cetera. And so often you want to give the beneficiary some benefit for the fact that they're not going to have to, the estate's not going to have to hire a real estate agent. So, maybe you want it to be the full amount, which is 5% typically, or maybe, some lesser amount and share that savings between the beneficiary and the estate. Those are all options to think about. Then there's the option that what happens if we get one valuation, but the beneficiary doesn't agree with it? Well, maybe we'll want to give the beneficiaries the option to get their own. And so we're going to build in some timing. They get the estate valuation, then they have 30 days to get their own evaluation. And those will be averaged. Then we have things like, okay, after you fix the purchase price, how long does the beneficiary have to exercise their option, say yes or no? Maybe it's 15 days. And then if they say yes, how long do we have to close? Maybe it's another 30 days. Okay. And then lastly, what happens to the proceeds from the option to purchase? Most often it would just fall into the residue, but you have further, you can do that complicated specific distribution as well. So that's what you would do. And then lastly, if the home is, if the beneficiary is not alive, what do you want to happen to the proceeds of the home and all of that? Well, we want it to just fall into the residue in this example, but you could also do a bunch of other options there as well. But this is your most typical. So that is how you create a home trust using eState. And I'm just going to create a will with this. So that's really what we've got for creating a home trust for a spouse. And I'll just show that to you and show you how that kind of comes out. And we always welcome, suggestions on on drafting. So if you've got, that's the benefit of eState, being a member of eState, is that we have 450 law firms who look at our drafting and say, I think maybe we should change this. And if we get a consensus and we all agree it's a good idea, then great, let's do that. So let's go down to the will. And so the way eState does it is it's going to create a trust for residents section here for this trust. And it does allow you to put in any further details. If you want to put in a PIN number or a legal description or something else, you can add that in. That's why that's highlighted. This is the drafting for any subsequent property. So for that. And then here is the beneficiary, the home disposition date that we set up, right? The termination of use. This is holding the home. This is the payment of expenses. So Marge is responsible for 100% of the utilities and ordinary repairs, and the estate is responsible for the balance. This is the section about buying a replacement property, right? And this is the option to purchase. So with all of the different, the trustees get a valuation. If any of the beneficiaries decide they don't agree with it, they can get their own. And then it's going to be you're going to average those and less the commission. So all of these are dynamically created. This clause is not just stuck together, like it's generated based on all of that different data that we put in. And so that's what we've got. And then basically we have, if the exercise, this is the exercise of the option to purchase. If it's not, then when Marge dies or doesn't want to live there anymore or cohabits or whatever, then it falls into the residue of the estate. Okay. So that's what we've got. So just wanted to point those things out. eState is going to warn us of something here. So there's a couple of warnings here dealing with the property. So the first is we've got a requirement that the estate pay expenses, but there's no residue. We haven't set up a trust for the residue, so it's immediately distributable. So here's our warning. Hold on a second. We better do some thinking about how is this going to actually get funded. And the other one to talk about is we terminated. We said that the beneficiary was responsible for certain expenses. Okay, we put that as a termination event, but we didn't talk about whether failure should terminate the trust or not. So we said, yes, she has to pay those expenses, but we didn't say if she doesn't pay the expenses, that's a termination event. So it's just telling us you might want to go back and check now and say, oh, maybe we should add in failure to pay expenses as another event that's going to terminate the trust or not. So there's eState that caught us from doing something wrong. So there's a bunch of questions. And I'll see if I can answer them. Ian, did you have anything else?
No, that's great. Thanks.
Great. So there was a few questions, and some of these are great suggestions, by the way. Excess proceeds being added to the fund for expenses. We don't have that option available, and I've never actually seen that. So that's something I'm going to put on our list to build, where you have the option with excess proceeds to go into the expense fund. So that's great. Thank you, Mark, for that. Then there's some questions to allow a spousal trust, right? So the rules changed about 5 years ago that trusts now, you can lose the principal residence exemption unless the home is, or any residence is held in a qualifying spousal trust. So the key there really is that the spouse is entitled to live there, or when the home is sold, that it falls into the residue of the estate, and there's a qualifying spousal trust for the residue, or there's a qualifying spousal trust for the proceeds of the sale of the home, if there isn't one in the residue. And so the way you would do that, just to be clear, is the gift over here would be dealt with, and you'd create a spousal trust for the gift over. So what you'd say is, if the property was sold during the lifetime of my spouse, then what I want to do is create a spousal trust for the proceeds. So that would be the gift over. We would run a macro. We could pick spouse trust, and it would then create a spousal trust for the proceeds of the sale of the home. And that would then protect the capital gains from being taxed from the date of death of Homer till the date of death of Marge. We're thinking of making that a little bit easier, Brody, so that's a great suggestion, but that's fine. You asked, is there a standalone option to purchase an eState? There is, and I'll just show you that in a second, and I'll demonstrate that in a moment. But I'm going to do it in another. I'll show you, Brody, for sure, but we're going to do a whole session on that as well. In this case, yeah, Colleen, the home was owned wholly by Marge, but eState's going to know that. It's going to draft it accordingly. So even if Homer didn't own the entire amount, that the drafting still works, because it talks about it being a partial interest. Because we don't know, even if today Homer owned 100%, at the time of death, he may not. And so eState drafts it accordingly for that. And I just want to demonstrate briefly how you might do a similar trust for the kids. And so again, this is descendants only. So now the kids are alive, Marge is gone, and we want to draft a trust for the home and let the kids live there. So we're going to drag the home into initial gifts. We're going to pick our beneficiaries. So I'm going to use a class gift. I'm going to let all the kids be able to stay in the home. I'm going to pick a trust. I'm going to apply it, substitute property, right? Because we want it to apply to any home that we have at death. And then the termination of use might be different. You'll see we don't offer cohabitation and remarriage, et cetera, because it knows that it's not a spouse that's the beneficiary. So we might say, listen, when all of the beneficiaries hit age 25, that's the end of the trust. So I would put in age 25, and then I'd select when all beneficiaries then. We could also terminate it when the first beneficiary reaches the age, but that doesn't make a lot of sense, I don't think, in this case. We might also say, listen, the trustee, you have discretion. Okay, even if my kids want to live there, it might not be a good idea to let the kids stay in this big, massive home. So I'm going to let the kids stay there, but terminate it when you think it's appropriate to terminate. And again, who's going to pay the expenses? And we run through all of those same options. You might say, well, I want to give an option of purchase to each of my kids. So not equally, but I want to make one kid have the first option, then the other kid, et cetera. If you're going to do that, then you've got to name them specifically, because eState, it won't work by a class gift. You can't identify that. So what we'd have to do is go back here. We'd edit the beneficiaries, and we'd pick the actual children specifically to be the beneficiaries. What does that do? Why did I do that rather than the class gift? Well, now that I would do if I wanted to allow an option to purchase, but I wanted an order of priority. Okay. In other words, I wanted to say, Lisa, you go first, Bart, you go second, Maggie, you go third. Or no, I want Maggie to have the first option. That's the only time you need to use specifically named people, which makes sense because you can't do it otherwise with a class gift. So that's how you do home trusts for kids, for spouses, for anybody. How you might do that. So I hope that makes sense. Ian, did you have any questions about or comments on that? I know you made a good point about it being a checklist and live, and you can go over these issues that, quite frankly, you would expect no client to know about. But go ahead.
No, it's just a constant reminder. When you're doing this, I went through this today with a client, and they were going through all sorts of variables, and I had to think. I couldn't, at the top of my head, I couldn't come up with all the variables. So I just opened up eState, and I went through the options and said, okay, what about this? What about this? And that was all. I'm just saying it's a tool that it just, sometimes on the fly, it's not easy to remember all of these variables. So it's not just about duration and amount. It can get more granular, and this helps you get through it.
Yep. And so the other thing is, like I said, feedback's great. So if there's, and we just got a great one, which was take the excess proceeds, dump them back, give the option to make them part of the expense fund. So that's what we're going to add to our list and make that available. If you see any other things that you think, well, this should be an option because I do it more than once, that's, let us know. You're not the only one. And so we'll take feedback and appreciate it. I did want to just answer the question about, is there a standalone option of purchase? So let me just show you how you might do that. I want to make the home, I want to give an option to purchase to one person to buy the home out from the estate. So I drag the home into the assets. I pick the beneficiary who's going to have that option. I go absolute and I go condition. And so if I go deduct from beneficiary share, they have the option to purchase. Now I have an option to purchase. So now they don't get the property, they have the right to buy it from the estate. And it's basically the same kind of thing. And that's how eState would do it. Okay. You can you modify the beneficiaries under certainly the same way by creating a trust for children, descendants? Yes, you can. So yeah, Brody, I'm going to get to that question in a second. Lindsay, drafting a home trust, one child is the use, but all have the option to purchase. It's cumbersome designing that. Thanks, Lindsay. I agree. And so what we're going to do in the option of purchase is actually give you not just we'll give you the choice of who has the option. So that's actually on our list. It's been on our list for a little while, but we recognize that. And so I will I take that point, and that's the great kind of feedback we appreciate, because obviously we don't have everything, and so but that's a great thing, and we already have that on our list. So thank you. So Brody, I just want to address this beneficiaries under certain age provision the same way as when creating, say, a trust for a child underage. So yeah, so just because we're answering a few other questions, let me just go to that. That's dealt with under provisions. So if you, on the left, if you pick provisions, we have the trust for beneficiaries under certain age. We can pick the age duration, and we can pick an interim distribution. We are considering allowing for more than one interim distributions, and we're just trying to gauge whether that's useful for people or not. Because again, this is supposed to be there for, non-complicated trusts for the remote issue that might inherit under a certain age, right? If you want to do something fancy, you probably should be doing it in the actual scenario planning. That's our theory on that. This is sort of your catch-all for any gifts to people who might be under the age. So hope that helps, Brody. So that's it for eState's for our user webinar. I hope you found that useful. There were I really appreciate the great questions, and we're going to add a few things to our list. And wanted to also let you guys know that as of today, there's some live new features, which I'm just going to show you briefly. The big one, and there's a bunch of them, and you guys are getting knowledge of this before anybody else. We now have fully editable provisions for powers of attorney. So if you're, for example, and I'm just going to demonstrate the power of attorney for personal care. So in your main screen, in your firm level screen, right, where you have clients, users, documents, go to documents, click on personal care, scroll down, you'll see contents options. If I click on that, here are all of the different paragraphs in your power of attorney, and you can choose to include them or not. So for example, I don't want to include an end of life clause. Or I have my own, okay? Or this client has one that I want to do. I can change my default to a custom and just paste it in here, and it's going to appear as a default every time. Okay, that's so now we're allowing that. You can do that for all of these different ones. We also added a keep at home one. So if you want to add some of your clients, or by default, you might want to have a keep at home provision that says, I want to allow my I want to stay at home. I don't want to be moved into a new nursing home. You'd go add content because it's a new clause. I go keep it home. So now I've added that to my my list of contents of my power of attorney. And if I go in there, the default is this simple one, but I might have a fancier one, and you can just do a custom, and it'll always appear in your by default in your documents. And these options can also be changed, by the way, at the client level. So if I'm working on Sarah's power of attorney and I'm generating it, I go down to the personal care. Maybe this one time, just for Sarah, I want to change that end of life clause. Well, no problem. I go to contents, and I want to change the medical treatment authorization, the treatment instructions, just for this client. So I can go custom and put this in. And that'll change it just for this client. So that's how you do it. And so as you know, if you've been following along, we're doing this for every document. We're making it all more and more customizable. You can change any of these. You can delete them. If you don't normally have a provision for expense payments, just exclude it and it won't be there. So you can customize that. And we're working on the ability to rearrange the order and add custom brand new clauses that we don't even have right now. So all of those, and that's available now for power of attorney personal care, power of attorney property. It's available in the will for your definitions. It's available for your admin provisions, and more as we go. Every few weeks that you'll be getting a newer and newer control over the contents of your documents. So just wanted to thank all of you. Again, feedback's great. We love it. We're building more and more stuff. So please keep it coming. And we'll see you again. Hopefully we'll see you Thursday when, Michaela, we're doing hodgepodge clauses and equalizing legacies and options for treating kids equal for making advances, gifts, or loans to them during lifetime. So hope you join us on Thursday for Ian and me joining us. And see you again next Tuesday as well. Thanks, everybody. Take care.